Yes.
My Lord, with profound respect,
Yes.
I am CF Famatea. I appear with the greatest respect for the claimant.
Yes.
Wait, please, my Lord.
The defendant not represented. Is defendant represented? Amatia?
My Lord, I can't see the defendant here. The defendant has no representation, as I can see here.
Okay. So this is a judgment of the court. The claimant filed a complaint pursuant to Order 3, Rule 2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 on the 4th day of May 2018. The claimant, pursuant to the order of this court, amended his originating complaint and filed the amended complaint on the 16th day of February 2023, whereas the claimant claims against the defendants the following reliefs: a declaration that the purported dismissal of the claimant by the first defendant is unlawful, null, void, and of no effect whatsoever, for being arbitrary and in non-conformity with the tenets and recognized practice and procedure for the discipline of erring members of clergy in the Diocese of Western Zone and the Anglican Church in general. A declaration that the suspension of the claimant by the first defendant for a period amount to approximately 12 months without recourse to the established procedure for disciplinary erring members of clergy in the Anglican Communion of the Diocese of Western Zone is arbitrary or lawful and no effect whatsoever. An order of this honorable court reinstating the claimant back to his position as resident pastor of the Peace Community Church Alebri and missionary in the Asampo Archdeaconry with all entitlements, rights, and privileges attached thereto, and without any loss of promotion with effect from the date of the purported dismissal. An order of this honorable court directing and compelling the defendants to render an unreserved apology to the claimant for his wrongful acts of suspending and dismissing the claimant without recourse to due process as recognized in the diocese, the sum of 5 million naira as general damages, and then the omnibus prayer. The claimant predicated his claim on the statement of fact filed on the 16th day of February 2023 and the witness statement on oath filed on the 4th day of May 2018, and reply and further witness statement on oath filed on the 10th day of February 2019. The defendant filed a statement of defense on the 9th day of October 2018. At the plenary trial on the 3rd day of April 2019, where the claimant opened his case, the claimant, who testified for himself herein after referred to as CW1, identified his deposition made on oath filed on the 4th day of May 2018 and 10th of January 2019 and adopted same as his evidence in support of his case. The claimant tendered exhibit CW001 to CW007. After several adjournments for default of appearance of counsel for the defendant, on the 1st day of December 2023, the defendants were foreclosed from defending the suit, and the matter was adjourned for adoption of final written address. After the closing of this suit on the 3rd day of June 2025, the matter came up for adoption of final written address filed by counsel. Counsel for the defendant was not in court despite the service of the hearing notice of him, and he did not also file his final written address. Counsel for the claimant, CF Ameta, informed the court that he waived his right of filing a written address. Let me briefly state the case of the claimant. The facts of this case as pleaded by the claimant is that he is a pastor in the service of the Diocese of Western Zone Church of Nigeria Anglican Communion. On the 11th day of February 2018, he received a letter from the first defendant, captioned letter of dismissal, dated the 15th day of January 2017, which said letter was signed by one Reverend Canon Anthony Odo, who is the administrative assistant to the first defendant. In the said letter of dismissal, the administrative assistant to the first defendant stated that he was directed by the first defendant to communicate to the claimant that he has been dismissed, equal to a letter submitted by members of the Peace Community Church, Alebri, dated the 22nd day of May 2016. Upon receipt of the said letter of dismissal, the claimant caused a letter to be written to the defendant through his solicitor challenging the decision to dismiss him and demanded his immediate reinstatement as pastor of the Peace Community Church at Alebri. The claimant stated further that he became pastor of the Peace Community Church at Alebri in Asampo of Diocese of Western Izon Church of Nigeria Anglican Communion, beared a letter of appointment dated the 5th day of October 2015, wherein he was appointed as a missionary and has been in the service of the Diocese of Western Izon till 11th day of February 2018, when he was served with a letter of dismissal from service by the first defendant. Prior to his purported dismissal from the service of the Diocese of Western Izon, he was arbitrarily placed on suspension by the defendant without recourse to the established standards and conventional practice duly recognized by the Anglican Church of Nigeria, including the Diocese of Western Izon, with regard to the discipline and punishment of erring members in the service of the church, especially as it pertains to in the pastorate or performing pastoral functions, on ground that he had embezzled church funds. The arbitrary punishment meted out on him by the defendant was communicated to him sometimes on the 4th day of February 2017, but that notwithstanding the fact that the said suspension order was in non-conformity with the recognized disciplinary procedure in the Anglican Church as observed by the Diocese of Western. He obeyed the order coming from his superior and as a result steered off the performance of his official duties and function as the resident pastor of the Peace Community Church Alebri in the Astampo, even though he continued to attend the church services as a member of the church. The claimant has just successfully defended himself before the disciplinary committee of the diocese at the headquarters of the diocese in Patani, when the first defendant slammed the suspension order on him without recourse to the recognized disciplinary procedure practice in the church. In line with the standard practice recognized in the Anglican Church and in the diocese, he was served with a letter of query dated the 3rd day of August 2016 by the Archdeacon Supervisor Reverend Canon David Obosindu, which letter of query he responded to in a letter dated the 30th day of August 2016, whereafter he was invited before the diocesan disciplinary committee, and he was cleared of the charges brought against him, even though no query was issued to him of allegation of embezzlement of the church funds. The first defendant suspended him without recourse to the appropriate authority and body for investigation and without any opportunity on his part to respond to the said allegation. The said suspension was verbally communicated to him while he was at his station in Alebi. The claimant remained under suspension from 4th February 2017 up to the 23rd day of January 2018, when, in view of the inordinate length of time without any inquiry made into the allegation endangering his suspension, he caused a solicitor's letter to be written to the first defendant, demanding for his recall. It was upon the first defendant receipt of the solicitor's letter dated 23rd January 2018 that the first defendant caused the letter of dismissal dated January 2017 to be served on him on the 11th day of February 2018. Although his dismissal was alleged to have arisen from a petition written by members of the Peace Community Church Alebri, he was never queried, neither was he invited to appear before the first defendant or the disciplinary committee of the diocese to react to the allegations made against him as contained in the first defendant letter of dismissal from the service of the diocese, and that the contents of the said petition by members of his church was never brought to his attention by the first defendant or any other person or authority in the diocese. The action of the first defendant, including the decision of the first defendant to dismiss him, the claimant, from the service of the diocese as a missionary, is irregular, null void, and of no effect whatsoever, as the claimant before his dismissal from service was never queried, invited, nor given the opportunity to defend himself before the disciplinary committee of the diocese, either orally or in writing. Let me briefly state the defense put up by the defendant. The defendant pleaded that the claimant is a civil servant with the Bayelsa state government and was a missionary engaged on voluntary service and not a pastor in the order of the Church Anglican Communion, Western Izon Diocese. The letter of dismissal was the last resort for a reprobate or repentant church worker in the person of the claimant who was given opportunity to repent from his arrogant and untruly behavior, but who deliberately refused to repent. Before the said letter of dismissal, the defendant issued a letter of query to the claimant, dated the 3rd day of August 2016. The ecclesiastical discipline of the Anglican Church, the defendant as the bishop occupies the highest office in the diocese and possessed with the right to discipline, suspend, or dismiss a church worker who is not loyal to constituted authorities under the episcopal jurisdiction of the defendant, as contained in the constitution of the diocese. The fact that the claimant was issued with a letter of appointment as a missionary to offer his services as a voluntarily lay church worker does not in any way grant him absolute independence, devoid of ecclesiastical discipline, as may be pleasing to the church authorities. It is the prerogative of the church authorities to place on suspension or indefinite suspension an erring member, erring church worker found of gross misconduct in violation of the Constitution of the Diocese of Warri, Anglican Communion, as applicable to the Diocese of Western East. Observations are made till acts of repentance are found in such a person. The defendant further stated that during the period of suspension of erring church person, however, in the claimant's case, the claimant saw himself as one performing pastoral functions and resorted to sending insulting and threatening messages to a defendant and his administrative secretary, whom he now wants to reinstate him. The claimant's claim was successfully defending himself before the diocesan disciplinary committee set up to look into the claimant's case does not in any way exonerate the claimant. The claimant's air of arrogance and superiority became more obvious throughout the committee sitting. The same arrogance and superiority are obvious in the claimant's reply to his previous query. The attitude of the claimant attests to the arrogance of a man who cannot see through the lenses of the leadership that gave him a platform for his purported pastoral work. By the letter of appointment given to the claimant was never placed on any emolument or financial benefit from the unit church or from the diocese for the fact the claimant is a civil servant who decided to sacrificially serve God and the church as a voluntary church worker. Thus, the claimant was placed on a monthly allowance of 3,000, subject to the availability of such fund in the church coffers at the end of the month. By the practice of the Anglican Church, the claimant was to take over the accommodation of his predecessor, and having been told by his predecessor that the church cannot foot the expenses of another accommodation, the claimant on his own volition lent his personal funds as support to the church without the consent of the church council. When the claimant made frantic effort to recover part of the fund he has committed to his accommodation from the church coffers without the approval of the church committee, the assistant auditors on the examination of the church account book discovered some discrepancies and the fact that the claimant was both a missionary and a treasurer. The office of which the defendant occupied is the bishop, the embodiment of rules and order in the Church of God, vested with the responsibility of presenting to the society men who are worthy in character and learning. Hence, the indefinite suspension of the claimant to check if he will be found worthy in due time. The claimant's subsequent action of serving the defendant with solicitor's letter demanding for his recall without corresponding act of repentance, forgetting that he was not engaged into the service of God's church via a solicitor's letter, and stated the need to serve the claimant with a letter of dismissal from his voluntary service as a non-stipendiary missionary from the Anglican Church, Diocese of Western East. Since the claimant has in the reply to supervisor's letter that he does not deserve to be disciplined, and his irrational attitude to the etiquette of the lay pastoral ministry attests to the same. The defendant, in line with the canons of the Anglican Church or within the church, deem it fit to dismiss the claimant from the service of the diocese without further query or hearing invitations. The defendant cannot shepherd a sheep who snub the counsel of his shepherd, but resort to the sending of text messages that insult the integrity of the office of an Anglican bishop occupied by the defendant. Having keenly studied the pleadings and the evidence led by the claimant in this suit, the issue for determination in this suit is whether the claimant has proved his case on the balance of probability to sustain the claim of the claimant against the defendants. I have carefully analyzed the process filed by both parties. It is an ultimate principle of law that the burden of proof lies with the party who will lose if no evidence is presented. It is after the claimant has proved his case that the evidential burden now shifts the defendant to dislodge proof of the claimant. Evidential burden of proof arises after the satisfactory discharge of the legal burden of proof, which is the foundation upon it can shift from one side of a case to the other. Where a party fails to discharge the legal burden or onus of proof placed on him, the basis on which the evidential burden can arise will be absent or non-existent. See the case of Federal Republic of Nigeria against Mahmoud. In the case of APC against Obaseki, reported in 2022, 2 NWLR Part 1814 at page 273, the Supreme Court held, and I quote, "It was the appellant hearing as plaintiff that desired that the trial court grant the relief they claim for on the basis that the facts they assert in their pleadings exist. And it is their case that will fail if they fail to adduce evidence to prove the existence of those facts. They can secure the favorable judgment they desire on the strength of their case as established by legal evidence and not the weakness or absence of a defense. Therefore, the legal burden of proof to prove the said facts upon which the success of their case depends rests squarely on them by virtue of Section 131, 132, and 133(1) of the Evidence Act 2011. By virtue of the provisions of 133(2) of the Evidence Act 2011, the plaintiff's evidence must establish their case before the evidential burden to rebut the case established by their defense can shift to the defendants. And if the plaintiff's evidence fails to prove their case, then the case collapses and must be dismissed, unquote. In this instance, the claimant who seeks relief against the defendant has the burden to prove his claim. If not, the case of the claimant will fail like a pack of cards. A careful reading of the pleading and evidence presented by the claimant before me reveals that the crux of the claimant's claim is that his suspension and termination of employment are not in conformity with the recognized disciplinary procedure of the Anglican Church, as observed by the Diocese of Western Europe. Now, the question that comes to my mind here is, what are the recognized disciplinary procedures in the Anglican Church as observed by the Diocese of Western Europe? It is a disservice to the claim of the claimant, where the claimant fails to present the alleged recognized disciplinary procedure in the Anglican Church, as observed by the Diocese of Western Europe, and how the defendant breached the recognized disciplinary procedure in the Anglican Church, as observed by the Diocese of Western Europe. In the case of African Bank, Nigeria PLC against Osisai, the Court of Appeal held, and I quote, "It is settled law that in an action for wrongful termination of an employment, the onus is always on the plaintiff to prove the terms of the agreement allegedly breached. It is from the terms of agreement which is binding on both parties that a court will determine the terms of the contract between the parties and the right of the parties thereto. The law is so well settled that when an employee complains that his employment has been wrongfully terminated, that employee has the onus, one, to place before the court the terms and conditions of contract of employment, and secondly, to prove in what manner the said terms were breached by the employer. The terms of contract of service is the bedrock of any case where the issue of wrongful termination of employment calls for determination, unquote. It is therefore the finding of this court that the claimant fails to prove how his suspension and dismissal from the service of the diocese as a missionary violates the terms of contract of employment contract with the defendant, and I so hold. Before I round up this judgment, there are three categories of employment. That is the pure master-servant relationship, and servants who hold their office at the pleasure of their employer, and employment which has statutory level. In the instant case of master-servant relationship, the master has an unfettered right to terminate the employment. However, he must comply with the procedure stipulated in the contract. In a contract with statutory level, the employment is protected by the statute. In the event of termination of employment with statutory labor, strict adherence must be had to the statute creating the employment. See the case of Obuwe against Delta Company Limited, Longi against First Bank Nigeria PLC, Mobile Producing Nigeria Limited against Johnson, and Oforishi against Nigerian Gas Company Limited. Even if the claimant was able to prove that his dismissal from the service of the diocese as a missionary is not in conformity with recognized procedure in the Anglican Church as observed by the Diocese of Western Asia, the court cannot order for the instatement of the claimant because the employment of the claimant is certainly not closed with statutory labor. In IHABUMHB against IE, the Supreme Court held that, and I quote, the court has no jurisdiction to impose a servant on a willing master unless the appointment has a statutory labor, meaning that there is no right of reinstatement of the respondent where it is found that her appointment has no statutory labor, unquote. In view of the foregoing, the law issue for determination is resolved in favor of the defendants. The claim of the claimant is very weak, and accordingly, the claim of the claimant is dismissed for being that of merit. I decline to award any cost and judgment is hereby entered accordingly. Okay. Yes, Pamata.
My Lord, I appreciate the court for this judgment, for insightful analysis and the entire rendering of the judgment. We are grateful, my Lord. We are grateful.
Thank you.
Yes, my Lord.
All right. Okay.